What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Tuesday, September 16th. Donna Adelson has filed a motion for a new trial and for leave to interview jurors. As you guys know, some of the jurors have spoken out, including the jury foreperson on TikTok, and a couple of other jurors have also given interviews with the media. So let's read through this and see what she's saying. They're asking the court grant a new trial, and in support thereof states as follows. Number 1, a jury convicted Mrs. Adelson as charged in the indictment on September 4th, 2025. Number 2, this motion is timely filed within 10 days of the verdict. Number 3, Mrs. Adelson requests leave to interview juror number 5 and juror number 7. Number 4, Mrs. Adelson files this motion for a new trial on the following grounds. 1, juror misconduct. 2, verdict is contrary to the law or the weight of the evidence. 3, the court erred in a decision of any matter of law which arose during the trial. And 4, for other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Okay, well, that's bold. So let's go to the first section, motion for leave to interview jurors. In a footnote, it says, although the jurors have identified themselves through social media or media appearance, the court previously ordered the parties to refer to the jurors by their juror numbers. And we're back to number 5. In the court's preliminary instructions to the jury, the standard instruction was read. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media, or a website, or any other form of communication. That's the admonition they get when the trial is actually happening. Let's see what number 6 says. Subsequent to the trial, Juror 7 went viral on TikTok concerning her jury service. She revealed she posted a TikTok during the trial. In reviewing Juror 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. A flash drive with this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by the juror from her account. The undersigned seeks to interview Juror 7 concerning her social media activity during the trial. Additionally, Juror 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. There is a footnote here that says, based on the court's numerous admonitions to Mrs. Adelson during trial, she was prohibited from expressing any emotion during the trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Mrs. Adelson's reaction whatsoever is concerning, as her reactions are not evidence and are external, rather than that which inheres in the verdict. Number 9, as a result, the undersigned seeks to interview Juror 7 concerning his consideration of Mrs. Adelson's reactions to the evidence. The next section is juror misconduct, discussion of law. They quote some different cases. It says, according to the Florida Supreme Court, potentially harmful juror misconduct is presumptively prejudicial. That's Amazon versus State, and see also Norman versus Gloria Farms. A party seeking a juror interview does not have to conclusively establish that the alleged juror misconduct occurred and actually prejudiced his case. They cite some other cases. Rather, it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Number 11, once improper contact or juror misconduct is established by a juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate there is no reasonable possibility that the juror misconduct affected the verdict. Number 12, if juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. We'll see where that goes. I don't think that him saying that he watched her body language is a big deal. More if the person on TikTok identified herself as a juror. In this case, we'll have to see where that goes. I'm not sure. We need to talk to a lawyer. So I'll see what I can find out. Part 2, verdict is contrary to the law or the weight of the evidence. Discussion of law. Number 13, the only avenue for judicial review of the weight of the evidence is by motion for a new trial at the trial court level. They cite Kelly versus State and Robinson versus State. In Robinson, the court stated that the rules of criminal procedure and the court continue to recognize the critical need for some form of discretionary judicial review to serve as a safety valve in those cases where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. Number 15, a motion for a new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act, in effect, as an additional juror. Number 16, this standard is different than the one used by a court in ruling on a motion for a judgment of acquittal, which utilizes a sufficiency of the evidence standard. And they cite Veloso versus State. Number 17, Florida courts have held multiple times that when considering a motion for a new trial based on a claim that the verdict is against the weight of the evidence, the trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Number 18, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. Number 19, when determining the weight of the evidence, in essence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. And they cite State versus Hart. The role of the trial judge in passing on motion for new trial on the grounds that jury verdict is contrary to the weight of the evidence is to weigh all of the evidence and determine credibility of witnesses so as to act, in effect, as additional juror. Count 1, first-degree murder. At this stage, the court must make a finding that Patricia Byrd was credible before considering Mrs. Adelson's alleged confession to Byrd. Under no set of circumstances can Byrd be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Kahn was obviously not white. Y'all, that's a little desperate, but let's keep going. Number 21, she further testified that she told both Mr. Varnes and Ms. Kahn that Mrs. Adelson confessed that Mrs. Adelson offered her financial incentives in exchange for perjured testimony. Both Mr. Varnes and Ms. Kahn disputed those claims. Number 22. Additionally, Ms. Kahn testified she never met with Mrs. Adelson. Thus, unless the court were to believe defense counsel conveyed to Ms. Kahn that Ms. Byrd was to be offered money for false testimony, Ms. Byrd's testimony should be disregarded completely. Number 23. The same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison release reoffender, Bernhardt's credibility was significantly impeached. The only one who testified this was Mrs. Adelson's words rather than Ms. Bernhardt, was Ms. Bernhardt. However, the surveillance video admitted into evidence establishes that she and Mrs. Adelson worked together to write the script. But Don still worked on that script, right? Number 24, the theory of the state's case was the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine Magbanoa, Sigfredo Garcia, and Luis Rivera, and that she paid for the crime to be carried out. There is no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed, and for that reason, the evidence is not sufficient to support her conviction as a principal to first-degree murder. Additionally, there is no evidence other than the adoptive admission from Charlie Adelson's trial testimony that Mrs. Adelson was aware of her son's plans until September 17th, 2014. Number 25. Although a person can be convicted as a principal to a criminal offense based on words alone, and they cite William versus State, there must be competent, substantial evidence these words were spoken in advance of the crime. A person can be convicted as principal to a crime under Florida statute only if there is evidence that he or she committed some act or uttered some words to assist another in the commission of the crime when the crime was being carried out. The elements of the crime are set out in the leading case of Staten versus State as follows. In order to be guilty as a principal for a crime physically committed by another, one must intend that the crime be committed and do some act to assist the other person in actually committing the crime. As acknowledged previously, intent is an operation of the mind and may be established by circumstantial evidence. There certainly is no direct evidence Mrs. Adelson intended for Mr. Markel to be killed. However, there also is no circumstantial evidence that Mrs. Adelson wanted Mr. Markel to be killed. Even if there is no evidence to establish the second element that she did some act to assist the other person in actually committing the crime. Magbanawa testified that per Charlie Adelson, his parents had stopped by his residence on July 18, 2014, after Mr. Markel was murdered. However, Magbanawa did not testify that Mrs. Adelson or her husband dropped off any money that night, and the state's expert agreed the state could not place Mrs. Adelson or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18, 2014. Even if Mrs. Adelson and Dr. Harvey Adelson did stop at his residence, it would have been approximately 9 hours after Mr. Markel was shot. Number 27. In fact, at the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid Magbanawa from his own money, which he kept stapled, as confirmed by Katie, Ryan Fitzpatrick, and Charlie's ex-girlfriend, June. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Magbanawa for the shooting until September 17, 2014. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17, 2014. Number 28. The defendant in Staten drove the perpetrators to the scene of the crime and then drove them away in the car. In these circumstances, the jury could legitimately infer that petitioner was a participant in the crime, and thus the Supreme Court concluded that the evidence supported the defendant's conviction as a principal. Affirmative acts such as these are common in prosecutions under the principal statute. Number 29, writing for a unanimous court in Ammons versus State, Judge Brad Thomas explained the rule as follows. To sustain his conviction as a principal, the state was required to establish that the appellant intended that the crime be committed and do some act to assist the other person in actually committing the crime. That was Staten versus State. Judge Thomas noted that he was emphasizing the phrase do some act in the quotation from Staten to explain why the court was reversing the defendant's conviction. Although there was evidence that the defendant intended to participate in the crime, there was no sufficient evidence that he did some act to assist in the commission of the crime. Number 30. In this case, as in Ammons, there is no evidence the defendant did some act to assist in the commission of the crime. The most that the evidence shows is that she knew of the plan at some point. That is not sufficient under the rule in Staten and Ammons. Number 31. Additionally, in Williams, the court held that even taking a broader view of the murder of Mike, the scheme that preceded his death, whereby Denise was to make sure Mike went on the trip with Brian. There was no evidence regarding what she did rather than what she was supposed to do in furtherance of the scheme that day. As we have explained, proof of the conspiracy alone is not enough. Agreeing with someone to commit a crime or developing a criminal scheme with someone else by itself does not establish that the person assisted in the eventual actual commission of the underlying offense. At a minimum, there must be proof of some overt act or some words uttered in furtherance of the scheme that led to the murder. The state offered no such evidence at trial. Number 32 is the Williams case continued. There still needed to be evidence of what she did to assist Brian as the offense unfolded. There was no testimony that Denise assisted Brian at the lake as the murder happened, nor any testimony that Denise was on the phone with Brian while he was at the lake with Mike, encouraging him to go through with it or giving him advice or guidance on how to pull the murder off when things were not going as they had originally planned. In fact, there was no testimony about anything Denise did, any acts or words uttered to facilitate the offense, to encourage the offense, or to direct the offense at any point during that fateful day. To establish a criminal conspiracy, an agreement, and intent that the underlying crime occur are all things that must be proved. Not so when proving principal criminal liability. The legislature eliminated the requirement that there be proof of a defendant's presence at the scene of the crime. It did not eliminate the text's requirement that there be proof of what the defendant did or said in connection with the unfolding of the crime that helped in its success. It is this proof that was missing from the state's case. Even when there is a scheme that precedes the murder, the crime is complete upon the victim's death. Unlike with a robbery, where the crime continues through the escape, evading detection of the murder after the killing would not be part of the crime. Number 33. The state may argue that Mrs. Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there is no evidence of what Mrs. Adelson agreed to pay the killers prior to the murder. In fact, Katie testified during trial the amount of the payment was never addressed prior to the murder. Number 34. The state may also argue that Mrs. Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to Katie, who then gave it to Garcia and Rivera. However, there is no evidence the tag number was ever given to Charlie, let alone Katie, Garcia, or Rivera. Even if such evidence existed, there is no evidence this was done on or even before July 18, 2014. No evidence was admitted during trial to establish the purpose for which Mrs. Adelson had the tag number in her 2014 planner. Finally, with respect to the second principal instruction, 3.5b, there is no evidence Mrs. Adelson made any payment prior to the murder, or that she, rather than Charlie, promised any payment prior to the murder. At worst, even if Mrs. Adelson dropped cash off at Charlie's house after the murder and signed the payroll checks after the murder, would establish her culpability as an accessory after the fact, but are not competent evidence as a principal to first-degree murder. Moving on to count 2, conspiracy to commit first-degree murder. Number 36. The state's theory on count 2 was that Mrs. Adelson agreed with Charlie and others to kill Mr. Markel. Number 37. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy the state proved as to Charlie Adelson, Katie, Rivera, and Garcia. Moving on to count 2, conspiracy to commit first-degree murder. Number 36. The state's theory on count 2 was that Mrs. Adelson agreed with Charlie and others to kill Mr. Markel. Number 37. As was clear throughout the trial, there was no direct evidence of Mrs. Adelson's involvement in the conspiracy the state proved as to Charlie, Katie, Sigfredo, and Rivera. Number 38. The primary evidence against Mrs. Adelson was the motive. Mrs. Adelson desired to have her daughter and grandsons moved to South Florida. 39. Although there was certainly evidence Mrs. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process, there was no evidence Mrs. Adelson said or did anything to suggest Mr. Markel be killed a year after relocation was denied and the dissolution of marriage had been settled. There was also no evidence Mrs. Adelson was even aware, according to Jeff Lacasse, that Charlie Adelson looked into hiring a hitman in the summer of 2013. Number 40. In order to establish prima facie case of conspiracy, the state had to admit evidence that A, the intent of Donna Adelson was that the offense of first-degree murder would be committed, and B, in order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charlie Adelson, Katie Magbanawa, or other persons to cause first-degree murder to be committed by either of them or one of them or by some other person. Number 41. The undersigned asked the court to consider the evidence without the state's spin placed on it. Certainly, Mrs. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markell to change his mind about relocation. Once the dissolution was final on July 31st, 2013, what evidence exists that Mrs. Adelson continued to have a motive for Mr. Markell to be out of the picture? They put in parentheses, if we ignore the emails where she suggested her daughter ensure Mr. Markell be obligated to share expenses with her for their son's college education, etc., all events which would necessarily take place after he was killed. There is none. 42. Where is the evidence Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markell be killed? There is none. 43. The state's entire case is premised on speculation, impermissible stacking of inferences, and theory. Without the speculation, theory, and impermissible stacking of inferences, there was no evidence Mrs. Adelson ever agreed for Mr. Markell to be killed. 44. The evidence of flight was not that she was fleeing to avoid prosecution, but at that time, in November 2023, she believed in her son's innocence and that if he were convicted, the state would next turn their attention to her. Rather than consciousness of guilt, that is evidence of her real fear the witch hunt would continue. Okay. 45. The trial court must exercise its discretion to determine whether a greater amount of credible evidence supports one side of an issue or the other. Although the fancy presentations prepared by the state may have been persuasive to the jury, Mrs. Adelson asked the court to look objectively at the evidence, removing the improper stacking of inferences on which the jury verdict is premised. Moving on to count 3, solicitation to commit first-degree murder. Number 46. The state's theory on count 3 was that Mrs. Adelson convinced her son Charlie to find someone to murder Mr. Markell. 47. The charge of criminal solicitation requires evidence that the person intends for the crime to be committed and that she commands, encourages, hires, or requests another person to engage in specific conduct which would constitute the commission of the crime. 48. As the jury instructions set out, the state must prove beyond a reasonable doubt that A. Donna Adelson solicited Charles Adelson or Catherine Magbanawa or other persons to commit first-degree murder. B. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine Magbanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. Number 49. The evidence admitted at trial failed to establish that Mrs. Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markell. Number 50. Rather, the component substantial evidence establishes that when Charlie was speaking with Katie concerning Mr. Markell, he would at times make or receive calls from Mrs. Adelson. Katie did not testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. Number 51. As with the argument concerning count 1 above, the evidence may have established her involvement after the fact and her complaining to Charlie about how Mr. Markell treated Wendy Adelson. There was simply no evidence she commanded, encouraged, hired, or requested that Mr. Markell be murdered prior to the murder. Number 52. Common sense and the plain language of Florida statute required the solicitation be committed prior to the crime. 53. With there being no testimony from any witness or any evidence admitted that Mrs. Adelson asked anyone to murder Mr. Markel, the entire premise for her conviction on count 3 is simply speculation and, as argued in court, an improper stacking of inferences. For these reasons, Mrs. Adelson's conviction on count 3 should be set aside and a new trial granted. The next section, the court erred in a decision of any matter of law which arose during the trial. Number 54, the court erred in denying Mrs. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. Number 55, during the trial, the defense sought to admit the complete planners to correct the misrepresentation expected to be made by the state and which came to fruition during the state's closing argument. Number 56, the state argued that Mr. Markel's tag number in the 2014 planner was evidence Mrs. Adelson provided the tag number to the shooters, despite there being no evidence this happened. Rivera testified there were words on the photograph given to Garcia, but no evidence was offered as to what those words were. Number 57, with the 2023 planner, the state argued the planner indicated, in anticipation of fleeing the country, that Mrs. Adelson was selling personal items. Admission of the complete planner would have corrected the misrepresentation by the state that there were 39 other entries in the planner where Mrs. Adelson listed to sell the identical items as far back as January 2023. 58. In Curtis v. State, the court recognized that judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. As the court admitted portions of both planners, there is no question concerning the authenticity of the materials. Exclusion of the planners infringed on Mrs. Adelson's right to present a defense, and the evidence was important to defeat the argument that she was fleeing to avoid prosecution. Thus, the court erred in excluding the planners as evidence. The next section, for other cause not due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. Number 59, it goes without saying that all defendants are guaranteed a fair and impartial trial under the Florida and United States constitutions. 60, the Due Process Clause of the 14th Amendment guarantees the right of state criminal defendants to be tried by an impartial jury. They cite Woods versus Duggar. The 14th Amendment incorporates the essence of the Sixth Amendment rights to be tried by a panel of impartial, indifferent jurors, whose verdict must be based upon the evidence developed at the trial. They cite Irvin versus Dowd. As Chief Justice Warren has observed, the constitutional guarantee of due process requires the courts to safeguard against the intrusions of factors into the trial process that tend to subvert its purpose. Specifically, the courts must guard against the atmosphere in and around the courtroom becoming so hostile as to interfere with the trial process, even though all the forms of trial conformed to the requirements of law. 61. The court explained in Schutz versus State the presence of courtroom observers wearing uniforms, insignia, buttons, or other indicia of support for the accused, the prosecution, or the victim of the crime does not automatically constitute denial of the accused's right to a fair trial. See also Holbrook versus Flynn. And then they cite Carey versus Musladin. However, there are situations where the atmosphere in the courtroom might infringe on the defendant's right to a fair trial. When such a claim is raised, a case-by-case approach is required to allow courts to consider the totality of the circumstances. A defendant claiming she was denied a fair trial must show either actual or inherent prejudice. Actual prejudice requires some indication or articulation by a juror or jurors that they were conscious of some prejudicial effect. They cite Pozo versus State. Inherent prejudice, on the other hand, requires a showing by the defendant that there was an unacceptable risk of impermissible factors coming into play. Number 63. This is a case where the cumulative effects of a number of factors constitute inherent prejudice resulting in Mrs. Adelson not receiving a fair trial. 64. When the court would rule against the defendant on many occasions, the members of the gallery supporting the state would laugh out loud. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery this was not acceptable. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated his order. This undermined the credibility of the defense in the eyes of the jurors. 65. Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. 66. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. That law does not require that a defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in the case may cause the jury to believe the defendant had no care or concern for what the victim endured. 67. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. She did become tearful during her first sight of autopsy photographs and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out loud. She did not need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during the trial. This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. Look, she could have shed some tears, and she also could have got up on the stand and told her side of the story, but let's move on to 68. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense case, the court demanded Mrs. Adelson decide whether she would testify. Both counsel for Mrs. Adelson, as well as Mrs. Adelson herself, repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial in order to make a knowing and intelligent decision in what was probably the most important decision in her life. This was especially significant in that the state made numerous changes to evidence during the trial. Number 69. When the court recessed early on September 2nd to allow counsel to meet with Mrs. Adelson, we first spent a great deal of time reviewing the exhibits actually admitted so we could discuss them with Mrs. Adelson. Counsel then drove to the detention center to meet with Mrs. Adelson for 2 hours authorized, arriving approximately at 5 p.m. Counsel did not have enough time to go through every exhibit with Mrs. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Mrs. Adelson's decision. Number 70. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt because they were continuing to speak to their client about this important decision that she had to make, which again brought an audible derogatory response from the gallery. Number 71. Oddly enough, whenever the state needed additional time to set up electronics for opening statements, for witness testimony, closing arguments, and even additional time to make their closing argument, the court not only gave them the additional time, he joked with the prosecutors about it, thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude its closing argument. The defendant's request was not granted and made a huge impact on the outcome of this case. 72. The court showed favoritism to the state at most every juncture of the trial. While the trial had delayed starting times to accommodate the state's needs, the defense was required to meet its tasks over the lunch breaks, thus not allowing counsel time to adequately meet the obligations of counsel for the trial, resulting in the inability to consume lunch over the break. Number 73. The court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense request to approach. Additionally, even when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury the objection was overruled. 74. During one sidebar discussion, the court asked counsel a question. As counsel attempted to answer the question, counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering the court's questions. 75. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on the part of the court to not only the defense but spectators in the gallery, the media, and those viewing the trial through the media. Fellow defense attorneys commented they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed toward Mrs. Adelson and her counsel in this case. 76. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome over another, and that was read in this case, it is not realistic that a jury can set those feelings aside. The jury clearly disregarded the instructions of the court on other issues and did so on this instruction as well. 77, the year I was born. Birthday this Sunday, by the way. The totality of circumstances present during Mrs. Adelson's trial established inherent prejudice, to wit, that there was an unacceptable risk of impermissible factors coming into play. Wherefore, the defendant respectfully requests that this honorable court grant this motion, grant Mrs. Adelson a new trial, and for such further relief as is just and proper. And this was filed yesterday at 9:08 p.m. So I cannot wait for the prosecutors to respond to this. And when they do, we will wrap it up in another episode. But y'all, that was a lot. That is it for today. I hope you guys have a good rest of your evening, and we will see you soon.